Hi, welcome everybody. This is Eric Rodebois from EPGD Business Law. We're recording this video, so it'll be shown sometime in the future. We're here in Miami, Florida. Look outside, we actually have a little bit of blue skies and sunlight, which those of you who live here know how precious that seems to be. So today what I want to talk about, in a nutshell, is writ of garnishment. Okay, now there's a couple different meanings for that, and what I'd really like to do, the intention was to look at it from the perspective of a business owner, but the fact of the matter is we represent business owners and employees all the time. So what is a writ of garnishment? So it is a writ delivered by some sort of authority. Typically the IRS can do writs of garnishment to garnish your wages if you owe tax money, and what they're going after is your W-2 wages. Okay, so you get a regular paycheck, your employer is reporting it to the IRS on Form 940 or 941 on a regular basis. They know where you are, they know who you are, they know that you owe money, it's connected to your social security number, and they go after it. And they can take up to 25%. Now, where it also comes up is in the, and maybe it's even a little bit more common, is it's one of the tools that a judgment creditor has in a civil suit. So let me walk you through that. Let's say that you have some sort of incident and you get sued. A car accident would be a great example. Breach of a business deal might be another example. Whatever it is. So you get sued in civil court for money damages. And at the end of the process, you lose, and there's a judgment against you, and it's an order of judgment, and a court is going to order you to pay money. Let's say you don't pay. Well, the judgment creditor, that's the guy who sued you who won, typically has three or more, but typically three common tools in their toolbox for how to collect that money, other than just threatening you or pressuring you. So the three tools are put a lien on real property. So if you have a house or investment property or land, they just put a lien on it. And what they've done is, whenever you decide to sell it someday, you've got to pay them off. That's what you're going to have to do in order to get clear title at the closing. Okay, so that's the first one. And frankly, that's probably the best tool in the creditor's toolbox. The second best tool is taking bank accounts. So that could be garnishing a bank account. And so if you owe someone money and they have a judgment against you, my advice to you is to keep relatively low balances in your bank accounts. Because if they hire a private investigator and find out where your bank accounts are, which by the way, no questions asked, I don't know how they figured that out, that's not my job. But let's say that the private investigator finds out that you've got an account at Bank of America, then what they do is they go to a court, they do it without your knowledge, and they ask for a writ of garnishment on the bank account, and they send it to the bank, and the bank freezes your account and writes a check for whatever's there. Now, there's more steps to the process, but that's generally what they're going to try and do. And then the third thing that they'll do is they will get a garnishment on your salary. So here's what happens. They do this without your knowledge, and then your employer gets a notice from the court, and it's called a writ. And so the employer gets the notice, and the employer has to respond within a certain amount of time. I believe it's 30 days. And so the employer has a certain, maybe it's 20 days. So the employer has a certain amount of time that they have to respond. Now here's the catch. If the employer blows it off, then the law, the court, whatever, just kind of assumes that the employer is helping out the employee, and they make the employer liable for the debt of the employee. So let's just use numbers. Let's say that the employee owes somebody $10,000, they get sued, they lose, there's a judgment, $10,000, maybe plus attorney's fees, maybe plus costs. And they go out and they look, and the employee doesn't own any property, and doesn't really have any bank accounts, but they find out where they work. So they send the employer a letter in the mail, it's certified mail, it might be served, and it's going to say, "Dear employer, please notify us in writing whether this person works here or not, and if they do, please start paying us a portion of their salary." Again, it's up to 25%. So all of a sudden, and this actually happened, one of my employers, the process server came in and served the secretary sitting at the front desk. The secretary just put it in the pile of mail. They didn't open the mail. 30 days came and went, and then voila, the employer now owed the $10,000 because they didn't comply with the court order. So, what's the moral of the story? If you are an employee, you need to figure out ways to settle your debts. If you get sued, you might have to have a hard conversation with your employer, letting them know that they need to let you know about the salary. Now, what some people will do is they'll go into business for themselves, maybe change the relationship to an independent contractor relationship with the employer. If you're the employer, please don't ignore the mail or the document that you just got served. Easiest thing to do is to pick up the phone and call the lawyer listed there. If you ignore it, chances are you'll end up owing that debt for the employee. Once again, thank you very much. This is Eric Rodabaugh from EPGD Land. Everyone have a great day.